The Eurobond debate was ignited by court leader Raila Odinga, whose stunning allegations that the country has lost 140 billion shillings in the sovereign bond transaction. And to rebut the allegations, Treasury came out armed with figures on how the money was spent, and almost in the same time, the Law Society of Kenya issued an ultimatum to Treasury Cabinet Secretary Henry Rotich to explain in detail how the billions of dollars borrowed in the international market through the Eurobond was spent. In a letter to the Cabinet Secretary and copied to the AG, LSK threatened court action to block the government from any further foreign borrowing if no explanation was forthcoming. But in a letter dated 15th December and signed by Mwangi Njoroge, the Chief Litigation Counsellor, the Attorney General explains in details why the funds from the sale of Eurobond were not paid to the Consolidated Fund. The AG quotes Article 206, which clearly stipulates that any money raised on behalf of the national government is to be paid to the Consolidated Fund. However, the statement further explains that the article anticipates expectations in a general rule in situations where monies are excluded from being paid into the Consolidated Fund by legislations but are instead paid into another established fund, or where monies are retained by a state agency for purposes of defraying expenses, which retention is authorized by legal provision in an act of parliament. And with that provision, the AG explains that since part of the money is raised through Eurobond was meant to pay a syndicated loan of $604.6 million, the National Treasury sought and obtained the approval of the Controller of Budget via requisition dated 28 June 2015, and that's why the payment was not made to the Consolidated Fund.